Some battles have been won, but the war is ongoing on Junior Sports Magazine versus Bonta. That is our lawsuit on the ban for youth advertising in California. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, the war wages on with AB 2571. That is the law that banned commercial speech towards minors on firearms in California. This is one that we haven't circled back to in a while, but we have some new developments within the lawsuit. And to walk us through that, we have brought back Anna Barver. She is a partner at Michelle & Associates. Anna, thank you very much for taking the time.
Thank you so much for having me.
Absolutely. And before we get into that today, guys, please, it is working. If you want to directly contribute to Second Amendment lawsuits like the one we're talking about today or towards legislative efforts, please be sure to like, share, and subscribe to these videos. That like button seems to have a huge impact on the algorithm these days. If any, go ahead and smash that like button. Make sure that this info gets out to as many people as possible. So Anna, I guess since this is kind of something we're revisiting, can you go ahead and just remind us of what this law, AB 2571, is, what it did, and why we decided to file a lawsuit on it?
Of course. So AB 2571 is what we call a minor, in short terms, we call it our minor marketing ban. So the legislature is urgency legislation that took effect immediately, decided that it was going to ban all marketing or advertising by only firearms industry members of firearms related products. And that's, again, just not just firearms, but also ammunition and anything per the definition in the law, anything that one would use in conjunction with their firearms. So holsters, your eye protection, anything like that you might be using on the shooting range. At least that's our position. And it's a ban on advertising and marketing of these products in a way that the firearm industry member knows will or is likely to be directed to or is reasonably likely to be attractive to minors. And that's a very broad, vague limitation. And so the law provided a non-exhaustive list of certain things that make a firearm or firearm-related product likely to be attractive to minors. So things like sizes of firearms that are made for young shooters and their smaller hands and body frames, using plush animals or mascots to market firearm products, creating firearm products in colors that are likely to be attractive to minors, whatever that means, as if there's a difference between what minors like and what adults like with regard to colors. So those kinds of things. And again, it was non-exhaustive. So anything that might be attractive to minors. The law also provides, bars firearm industry members from keeping the contact information of minors if they're going to use that information to market those products, those same products, firearm-related products, to minors. So just another way of banning firearm advertising to youth. The law includes civil penalties of up to $25,000 per copy of that's in violation of the law, and the Attorney General's office can bring it. Any county council, city attorney, or district attorney, or any individual person who claims that they were injured by the law. We brought a lawsuit immediately because we saw the extreme violation of First Amendment rights that this law it constitutes, the legislature immediately tweaked the law a little bit to protect the rights of youth shooting groups and some Second Amendment groups to do things. But overall, even with those fixes, the law still was a violation of the First Amendment in our position. So we brought the lawsuit.
Which is, yeah, and I don't know if you guys remember, but when this bill was signed into a law, the firearms community, specifically revolving around youth programs, was thrown through a complete loop. It was written so ambiguously that a lot of things just kind of came to a halting stop. Not a whole lot of people knew what they could do. And when you're talking about a $25,000 fine per incident, that can rack up pretty quick, not necessarily a liability that a lot of people in today's age can be taking. So definitely good that the lawsuit was brought, I guess in the post-Bruin era, specifically with the federal district court in California, as well as the Ninth Circuit. We've seen some lawsuits have kind of a not ordinary track through the judicial system. I think that one would fit into this as well. Can you go ahead and tell us the track that this lawsuit has kind of taken through the courts?
Of course. So along with the complaint, we pretty much immediately filed a motion for preliminary injunction seeking to enjoin AB 2571's enforcement in its entirety while while the litigation was pending. The federal district court in the for the central district denied that motion in its entirety, and we filed an interlocutory appeal to the Ninth Circuit. We were very fortunate to get, we had a great panel, including Judge Van Dyke, who we're all familiar with with his amazing dissents in our Second Amendment cases like Duncan. We had a great panel. They found 3-0 that the law was likely unconstitutional under the First Amendment commercial speech doctrine, and the law was likely unconstitutional in its entirety. The court issued, the state sought an en banc review, and the court did not, no member of the court even sought a vote to decide that they should. So the en banc petition was denied, which we're not used to seeing in our gun related cases whenever we get a pro-gun decision. So that was a big win, or at least we thought it was. Once the mandate issued, we went back down to the same judge in the Central District, who, after a lot of hand-wringing and going back and forth, the court issued a very limited preliminary injunction, in our opinion, in strict, clear defiance of the Ninth Circuit's 3-0 opinion, and issued mandate. This preliminary injunction that she recently issued, I believe it was on June 28th, limited only or enjoined the enforcement of only subsection A, which is only a portion of the law which sets out we're banning firearm marketing to kids, but left the state and its agents quite capable of enforcing the rest of the law, including subsection B, which prevents everyone, but especially our client, who is a junior shooters magazine, who has a youth shooters magazine, from using their subscription lists to send their magazines to them, because it bars them from using minors' information if they know they're using it to advertise firearms.
Okay, so far in this lawsuit, you have a preliminary injunction that's kind of limited to subsection A of the law. Something else that we've reported on is the SCI lawsuit, which has basically challenged the same thing. Can you go ahead and decipher this for me? Because as far as I understand, they got a preliminary injunction in their lawsuit as well, which is different from ours. How exactly do you have differing opinions like this all under the Ninth Circuit, and why is it important for both of these lawsuits to succeed?
That's a good question. So the reason we have two different outcomes here is because we're before two different judges, and because of the kind of shenanigans that were being pulled in our case, junior sports, if you recall, the Ninth Circuit decision in junior sports came down first. Our decision came down first, and it was the one that was the lengthy analysis. SCI's opinion was an unpublished, see what we said in junior sports magazines. That applies here too, because it's the same challenge, same outcome. So when those cases went back down, it took a little longer. There was some stuff happening from the state on our side that was pushing the case, that was delaying the case. And while at the same time in the SCI case, they were moving forward. They filed like a joint statement and asked for the injunction, and the court just granted it without any kind of pushback. And that injunction enjoins the entire law statewide. However, the state has recently filed a motion to reconsider that or to tweak the injunction so that it looks like ours. And that's being heard. I think it's being heard right now. So that could be changed to look just like ours. If it's not, we get into a little bit of a sticky situation, and I think it's still really important. I know that it's still really important for our appeal of the Central District decision in our case not to grant us the full preliminary injunction, because we've started to see some question coming from the federal courts about whether preliminary injunctions that are issued during litigation are widely applicable to everyone, or if they're only applicable to the named parties. And if we don't get an answer on that and it's not clear, then we leave our clients and everyone who's not named in this Safari Club lawsuit vulnerable. So it's not clear that the court wouldn't, make sure that preliminary injunctions widely and broadly applicable to the entire state. But there is a question, and we need to make sure obviously that everyone in the state is protected.
Which is why we kind of have this expectation, especially when CRPA files lawsuits. We're seeking to get rid of a law that we are claiming is unconstitutional. That doesn't mean it's unconstitutional for one person or one organization. That means it's unconstitutional for everybody. So coming in with that expectation and then having this different filter from the court basically saying, hey, we're going to start, maybe giving these injunctions, but only applying them to the plaintiffs in the case that's challenging it, seems kind of backwards to me. I'm sure it seems backwards to a lot of you as well, which is why we need to continue, I'm sure, and try to get the favorable decisions on all the lawsuits. So, having said all of that, where exactly are we in the case, and where do you see ours going forward?
So after the court issued its opinion with giving us a very limited preliminary injunction, we immediately filed a notice of appeal to the Ninth Circuit. Yesterday, we filed a motion requesting that the court assign our case as a comeback case under the Ninth Circuit's general orders. Some of you might be familiar with what a comeback case is based on the hijinks that ensued with the post-SCOTUS remand, back to the district court, back to the Ninth Circuit hijinks that played out. And while there was some real questions about whether that was appropriate, in this case, we filed this motion because, as I mentioned before, we had a great three-judge panel, and because this particular appeal is very limited to what that three-judge panel meant when it issued its first opinion. That's all this is about. So who better to ask and to decide that matter than the three-judge panel that issued that opinion and wrote it? They know what they meant. So we filed that motion yesterday. The state's not going to oppose it, which is good, but it will still be in the hands of that three-judge panel to decide whether or not they want to take it. I'm very hopeful, and I suspect they will. We are also in the working on, and we'll be filing very soon, a rule of appellate procedure 8 motion for preliminary injunction, so that the whole law is enjoined pending the outcome of our appeal. Even though this should be a pretty quick appeal, our opening brief is due on the 30th, I believe. So it should be a pretty quick appeal, but we want to make sure that, again, everyone in and out of the state that this law applies to is protected as long as the delay keeps happening. Also, it kind of gives us a little bit of insight, I think, into what our panel is thinking when they rule on that motion, because again, that motion is going to be, are we entitled to the full preliminary injunction? And that's what the case is about. So it'll be interesting insight. While a court may not want to just jump the gun and issue it, if we get a decision that it analyzes it, that'll really help, I think, guide our analysis that we want to bring in the appeal itself. So that's where we are.
Well, yeah, get it in front of a judge that we already know is going to be favorable to us, and make sure that we understood correctly and be able to enjoin the whole law. I ask this every time. I got to ask it again. You said some stuff was due at the end of the month. Is that something that potentially a preliminary injunction we end up seeing at the beginning of August?
I don't know how long. So the state has indicated that they will oppose our Rule 8 motion for the injunction, which I'm not surprised about. Obviously, that's their position. And they technically then get 10 days to oppose. I strongly suspect, especially if our initial three-judge panel is ruling on it, while the motions panel can decide it even without waiting for the opposition, if they're going to grant it, or I think no matter what, I don't think they're going to make a ruling without giving the 10 days to the state. So probably won't be any earlier than the end of this month. And if they take some time to sit on it, uh, it could take longer, but I think the beginning of August is a good time, is a good expectation of when we should see some sort of ruling either way. I think
Well,
so.
definitely something to look forward to at the end of the month. I know that you are extremely busy, Anna. I want to thank you very much for coming on and sharing this with us.
Of course, I am. I always love speaking with you and your audience.
Absolutely. And we thank you again. And guys, if you like content like this, if you want to continue to see videos on Second Amendment litigation in California and the Ninth Circuit from the attorneys that are advocating for you in court, please, again, be sure to like, share, and subscribe to these videos. It is a way that you can directly contribute to that litigation and to the legislative efforts here in California. Thanks again, guys, and we'll see you on the next one.